So then what's the problem? Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. So yesterday, most of you guys know that I was completely MIA because it was Ariel's 18th birthday, so I did not put a video out whenever these documents went live last night, but Wednesday evening I did drop a video going over the case summary because the case summary was updated with the titles of these before they went public. That's normally how it goes. This video is about one very specific document, and then I will drop another video sometime over the weekend about the rest of them. This one about the IGG is super important because this has been the most ass backwards fight of this entire case. We have literally had the prosecuting agency, technically agencies, trying to get rid of this IGG information since before Bryan Kohberger even got back to Idaho from whenever he was arrested in Pennsylvania. How does that even work? Some of you might ask that are new here, maybe. But all of my OGs know exactly what I'm talking about. Little Miss Dawn Daniels. Dawn Daniels is the one that executed the search warrant on Bryan Kohberger's apartment. And when she told the magistrate court everything about why this needed to be signed, in her supplemental narrative, she literally states how she asked for the IGG to be ignored, for them to make their decision about this search warrant without considering the DNA information that she already told them about. Then we had the state telling us from a long time ago, over 2 years ago now, that they were going to be trying to file a motion in limine in order to exclude the IGG from even being introduced at trial. They were trying to just get rid of it completely. Now the defense is asking for it all to be suppressed because they believe that Bryan Kohberger's DNA was obtained illegally, and they claim they can prove it with the Franks motion. Now the IGG has been super secretive this entire time. It's really been the most, like I said, the most ridiculous thing, because we've had all of these parties, literally every party involved, wanting to get rid of it in one way or another, yet it has literally been the most talked about subject. Honestly, look at all these videos that I've done on the IGG. We're going to talk a little bit about this as we're going over this document, but I did create a playlist because I didn't realize there were so many. I have at least like 14 or 15 videos where we've gone over all of the stuff that's been talked about when it comes to the DNA, when it comes to this case. The stuff where Gabriela Vargas was telling us all kinds of secrets about loopholes and crazy stuff. The articles that we found posted online that went completely with her narrative of the illegal things the police do in order to obtain DNA for all of this stuff. The way the S&P profile sequencing works. We learned a lot from whenever she took the stand, and then she had the feds come knocking at her door. A lot of stuff about her testimony was sealed and put away, but we've never heard that it's been actually removed from the docket, at least nothing that I have seen. The state has been wanting this suppressed and out of the public's eye from day one. Now, suddenly the defense wants to do the same, and a lot of people are acting like it's an issue for whenever the defense wants to do it, but no one cared whenever the state was wanting to do it, and that's just a mentality I don't really quite understand. Why is it okay for one but not the other? So here's the list. Right now, we're going to be going over the motion to unseal the IGG suppression briefing and hearing document. It's only about 4 pages. In the next video that I will get out on Saturday, probably in the morning, we'll go over the first supplemental response to discovery and all of the rest of these down to this notice of hearing. Okay, let's read through this and see what they have to say about this being suppressed and closed or not. Comes now Bryan C. Kohberger by and through his attorneys of record, and hereby moves this honorable court for an order to unseal the investigative genetic genealogy, also referred to genetic information or IGG suppression briefing and related hearing. First footnote. Big one. The related briefs are 1. Memorandum in support for motion to suppress regarding genetic information with attached exhibits filed under seal on 11/18/2024. 2, sealed objection to defendant's motion to suppress regarding genetic information with attached exhibits filed under seal on 12/6/24, and 3, reply to state's objection to defendant's motion to suppress in memorandum in support regarding genetic information with attached exhibits filed under seal. Procedural history. Mr. Kohberger filed his first motion to compel IGG discovery on June 22nd of 2023, and here we have our second footnote. Defendant's third motion to compel discovery filed on 6/22 of 23. So they're just giving the documents to reference. The hearing on that matter was public and involved the testimony of several expert witnesses. I just mentioned this. Exactly. It's literally like, I think the first video on the playlist I created, if I can remember the way that it looked whenever I was scrolling through it, is the stuff about Gabriela Vargas and her testimony. The court ordered the production of records in camera and under seal. And again, in camera does not mean anything with the camera. It literally just means that the judge in chambers privately gets to go through the information. That's whenever Judge literally cherry picked, because he got to see all of it and decided which portions of the IGG that the defense team should even be allowed to have. And it wasn't all of it. But then again, that's still up and down, which I discussed in that Wednesday video. Mr. Kohberger filed a second motion to compel IGG discovery on April 15th, 2024. Third footnote, with that document being the defendant's fifth motion to compel discovery, filed 4/15 of 24. Over the objection of Mr. Kohberger, the court required that portion of the May 30th, 2024 hearing on the second motion to compel IGG discovery be closed. We had a closed session. We had a public session. The court again ordered the production of records under seal. The court's concerns were the privacy rights of the names of individuals identified in Mr. Kohberger's family tree. Exactly. I mentioned this in the last video too, and we've mentioned this as we've been talking about this stuff. I completely understand wanting to protect the names and the identities of the people that are related to Bryan's family tree, regardless of his innocence or guilt. It doesn't matter. They don't have anything to do with this case. But what I don't understand is why they can't just redact it. Like, obviously, we ended up finding out who Dylan and Bethany were. We were going to because they lived at King Road, okay? But if they haven't already, removed this online, people already know. There's literally videos already from creators that after Bryan was arrested and we learned that, we were told that he apparently told a neighbor that he took some sort of ancestry DNA thing. And then we found out how ridiculously crazy and important that exact same thing was in the actual investigation. It lit fires under people, and they went out there trying to find his public profiles, and some people found them and posted videos of them going through Bryan's very public, on public websites, family tree that was available, again, to the public. Now, I'm not saying that just because there's some people that were able to get it publicly, that should mean that these people shouldn't be protected, their identity shouldn't be protected, but they definitely should be protected regardless of that, because they don't need to be doxxed or messed with or harassed simply because they share blood with somebody that's going through a murder trial. That's not fair. But they could easily redact the names to the public and just give everything over to the defense. What do they think that the defense is going to do? Throw the names out there to the public and say, okay, go fetch? That's not going to happen. At the first and second motion to compel IGG discovery, Mr. Kohberger argued that he would be filing a motion to suppress the IGG. He asked the court to allow the pleadings and hearing be public. On May 20th of 24, the court indicated it would take the matter up after the suppression pleadings were filed. In the interim, venue changed, and this case is now before a new judge. The motion to suppress regarding genetic information was filed on November 14th, 2024, and is now fully briefed. Pursuant to court directions, the parties stipulated to file all GG suppression pleadings under seal. No names of the extended family tree are discussed in the briefing. So then what's the problem? The matter is set for hearing on January 23rd and 24th, 2025. Mr. Kohberger requests that the briefing be unsealed and the hearing take place in an open court. Why would somebody who is guilty want you to hear all of this? Why would they now be begging for the cameras to be open? Because they've had enough. Maybe he went into this and thought that, let's suppress everything, or let's get rid of the cameras, and let's agree to this and let's agree to that, because there's no way this is going to go as far as they think it's going to go. But now it's at a point where they don't have a choice. And if the defense team really truly believes in Bryan Kohberger's innocence and he's going to stand silent while still trying to project his own innocence, fighting for this to go public is one of the best ways to do it. Again, that's just my opinion based off of what I'm seeing happening right now. And again, they are very much making it clear right here that there is no names or anything discussed in any of the information. So there's no reason for this to be sealed. None. Argument. Due to national and international attention to this case, and in the interest of protecting Mr. Kohberger's right to a fair trial, many pleadings in this case have been sealed appropriately pursuant to Idaho Administrative Rule 32. Mr. Kohberger has a right to a public trial, and sealing a suppression hearing is a clear violation of this right to a public trial. And then it goes on to list Weaver versus Massachusetts from 2017, Waller versus Georgia from 1984, State versus Ingraham from 2013, and then Cowles Pub Company versus the First Judicial District, and that was from 1990. In addition to Mr. Kohberger's right to a public trial, the public has a First Amendment right to know what goes on in its courts. Yes, it does. Yes, it does, especially whenever it comes to stuff like this, because this is not just something that affects just this case. I want you guys to look at this thumbnail. The link for this video will be down in the description box. This is just one video that I did about the craziness around ancestral DNA. That one very specifically is about 23andMe and how a lot of the genetic information is literally sent off to places that can make biological weapons based on your DNA type. Your DNA is not being stored because they want you to know what kind of condition that you might have because of your genetic predisposition, because your bloodline might be tainted for having certain sorts of cancers or certain types of thyroid issues, or maybe diabetes runs in the bloodline or heart issues. It's not for you to be protected. It's for them to harvest your information. Everything about you is worth billions of dollars to everyone else but you. And with what we heard from Gabriela Vargas, the way that they take your information, even if you opt out of sharing said information, the loopholes they've learned to become criminals in order to get criminals, is completely back-asswards. And something has got to change. And the only reason why I feel like they really want to suppress so much of this information when it comes to the DNA in this case in the beginning was because it was illegally obtained. I don't believe that the defense would be trying to put that information in here on record without them having actual facts, people to blame, and events to actually document. I don't think they can do that, because look what Richard Allen's defense team did. They took everything from the discovery that was literally created from the Odin report that was literally written and put together by freaking FBI agent. Again, lives lost and nothing but chaos when it came to the Odinism information in the Delphi case. It's all documented. It's all real. They knew what they were doing was wrong, and they stopped the public from seeing anything. Now, all we have is third-party interpretations and nothing to prove that Richard Allen actually did what they're accusing him of. Literally nothing. There's not one solid, concrete fact. Nothing. This is what's going to end up happening here. If this keeps on being suppressed, if they keep on having everything sealed off and they're not giving the public any information, how are we supposed to believe that they really got the guy? How are they supposed to believe that we are going to just sit back and take all of this in and not ask questions when nothing adds up? There's no connecting puzzle pieces here. None. They have yet to have one thing not be picked apart. Tell me one thing that they have told us in the probable cause order or from the very beginning of this that hasn't completely changed. Whether it comes to the case itself, the timeline, Bryan Kohberger, or anything, tell me one thing that hasn't been flipped, reversed, 180'd, or completely unraveled and disproven. There's not one single thing besides the fact that it is Bryan Kohberger's DNA. And that's the one thing here that he is not trying to dispute. He wants to find out how it got there. Literally trying to use all of the state's evidence to prove his innocence, just like he said he was. So far, it's working. Now, trial could change all of that. Trial could change, and the state could come out and be like, bam, 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 and bam. And we could all be like, holy shit, bro. Holy shit. That's just the reality of this. We're not going to sit here and pretend that that can't happen, because it can. But again, I find them wanting to have this open to the public so that everyone can see what's going on, so that we can hear what the Franks motion is, so that we can hear how they believe the DNA was illegally obtained, so that we can see the facts. It's not just beneficial to the victims and to Bryan and to the state and to the defense. It's beneficial to the public because we deserve to know the crap that gets pulled behind the scenes before we end up one of them. Because it could happen to you, it could happen to me, it could happen to your mama, it could happen to anybody. Lucas Anderson. We're just going to keep going back to that one. It goes on to state, Idaho Code 74-1041B recognizes that records contained in court files of judicial proceedings may be exempt from disclosure under rules promulgated by the Idaho Supreme Court. The Idaho Supreme Court adopted ICAR 32 to define when public access to judicial records may be denied. State versus Doe from 2012. When the court is considering whether to seal the record, Rule 32I directs the court to consider the traditional legal concepts in the law of the right to a fair trial, invasion of privacy, defamation, and invasion of proprietary business records, as well as common sense respect for shielding highly intimate material about persons. ICAR 32I3 under Rule 32I1, records may be sealed or redacted if the court determines and makes a finding of fact as to whether the interest in privacy or public disclosures predominates. The court's decision to seal judicial records is discretionary. Here, the way in which the IGG material was accessed and used is a matter warranting public disclosure and should not be shielded from the public's right to know. The matter is of utmost importance to Mr. Kohberger's right to a public hearing. Holding the hearing in open court will not prejudice the parties, and this should be held in open court. Yes, it should. All of it should. The issues raised are legal issues, and cases with similar issues are being decided in other states. I'm sure there's probably lots of stuff like this going on. The issues raised in Mr. Kohberger's suppression motion are those that were discussed in the public hearing on the first motion to compel, and the footnote 4, aspects of the IGG investigation in this case have already been leaked, and it goes to an article that we went over in full. Again, it will be in the IGG playlist, and again, down in the description, we'll have the link straight to the playlist. The article is called How Police Actually Cracked the Idaho Killings Case from Slate. You're going to see that in the thumbnail. We went over this. It talks about those loopholes and all the things. Additionally, the way in which IGG occurred in this case has been made public in other cases, and it says to see State versus Hartman from 2023. And then it mentions the information about how the Golden State Killer was actually found, which again, we've talked about DNA, IGG, the Golden State Killer case. It's basically the first domino that started all of this cold case stuff finally starting to be solved with the technology advances in DNA work. Conclusion: Mr. Kohberger has a right to a public trial, and the public has a right to know how genetic information was used in this case. Neither the state nor Mr. Kohberger will be prejudiced by unsealing the briefing and holding the IGG hearing in an open court. The pleadings and hearings should be unsealed. Yes, it should. I wholeheartedly agree. There is absolutely no reason for any of this to be sealed. There is absolutely no reason for any of this to be conducted behind closed doors without the cameras and the microphones on. There's literally no reason for it. If they've got their man, if they actually factually have the man who did this and their investigation is so solid, then what are you hiding? There are so many cases where the police come out here and they want all their information out because they want to boast about it. They want to boast about what they did because they're proud of their work. And they continue to be proud of their work. And they continue to give information about what's going on. So why all the secrecy, Moscow? Why do we have no clear-cut answers on literally anything in this case? Why is it that pretty much everything that they presented to us for Bryan being guilty has been pulled apart, dismantled, unraveled, reversed, flipped around, proven to be false? They're leaving this like this for what? Self-preservation on their own part? Probably. Most of people, like me, believe that this has just gotten to the point of no return. So now they really can only fight as much as they possibly can before we do get to trial and see everything. And I just don't believe that they're going to pull some magic trick out of their sleeve. They're not going to pull some rainbow rabbit out of a hat that's going to prove one way or another. Nothing that they have sticks. Nothing that they have makes sense. They've yet to make anything fit this. And again, I was MIA whenever these went live on Thursday night because we were out celebrating Ariel's 18th birthday. Thank you so much for all the birthday wishes and love. She very much appreciates all of that. So I want to know what you guys feel about this document, and how do you feel about the fact that now the defense team is fighting to have all of this stuff about the IGG and the DNA, which is technically the only thing that hasn't been misproven, is that this is Bryan Kohberger's DNA. The defense is like, yeah, it's his, but how the hell did it get there? The state's like, yeah, it's his, and we don't know how it got there either. But you know what? It doesn't matter because we got somebody arrested, and that's all that matters. Our little university town is going to keep getting their little tuitions, and we can just go on about our business. So let me know how you guys feel when it comes to what this says about the possibility that he could truly be innocent. Would a guilty man be wanting all of this out there in the open, knowing that something in there could actually prove his guilt if it's there? All I'm saying, think about it and let me know what you guys think down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.